morning.
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 If I could have a roll call first of the justices to make sure we are all here. Justice Gaziano was recused, so he will not be among us
Lank.
for this discussion. So why don't we begin with Justice Lank?
Lank.
Lowy.
Cipher.
Casper.
All right, and as to the attorneys, on behalf of Dorchester Mutual,
Kevin Truland, representing Dorchester Mutual, Your Honor.
and on behalf of Mr. Krusell.
Charles Beal, representing the Krusells.
All right, and hopefully we have Clerk Keneally. Are you there?
Yes, Chief Justice Gantz.
Okay, so why don't I believe Clerk Keneally furnished you the protocol, furnished all the protocol, but let me quickly go through it so that all understand it. Mr. Beal, of course, will argue first as the appellant. We'll give each of you roughly 3 minutes to speak without interruption from the justices. After 3 minutes, you'll be free to ask the questions. If you wish to invite questions before 3 minutes, you can simply say, Your Honors, I now invite questions. The questioning will begin with the most senior justice, which will be Justice Lank. We will then go by way of seniority and invite every justice to ask questions. I will ask questions last. And after I conclude my questions, I will invite the other justices, if they have any further questions, to ask them, and that will conclude. Each of you have 15 minutes. I have a timer here, and I will, at the 15-minute mark, without breaking into any question or any answer, identify whether it's 15 minutes, but we will continue until each of the justices' questions have been asked and answered. And if you are on a landline, if you have a cell phone nearby, please silence it. And apart from that, I believe we're ready to go. So, Mr. Clerk Keneally, can you please call the case?
SJC-12856, Dorchester Mutual Insurance Company, v. Timothy Krusell and others.
Good morning, Mr. Beal.
Thank you. Excuse me. Thank you and good morning. Mr. Chief Justice, Associate Justices, may it please the Court, my name is Charles Beal, and I represent the appellants Timothy Krusell, Peter Krusell, and Michelle Krusell. We have set forth several grounds for appeal in our briefs, but the primary ground for this appeal of the summary judgment decision below is that the motion court improperly found that the abuse and molestation exclusion was unambiguous as applied to the facts of this case, and that it also erred in finding that the term physical abuse could be read in isolation from the rest of the exclusion. And even if the term physical abuse could be read in isolation, the motion court further erred by adopting a definition of that term that is way broader than any commonly used definition of abuse, and that results in an exclusion that is way broader than was ever intended or expected. As to the interpretation of the exclusion, we start with its language, which excludes coverage for bodily injury, quote, arising out of sexual molestation, corporal punishment, or physical or mental abuse, end quote. The motion court, relying on the unpublished decision of Minnock v. Vermont Mutual, held that the term physical abuse could be separated from the rest of the exclusion and read in the broadest possible manner to encompass any physical maltreatment, whether intentional or not, and therefore barred coverage for injuries resulting from the one-time incidental contact between strangers at issue in this case. We would respectfully submit that by reading the undefined term physical abuse outside of its context within the abuse and molestation exclusion, the motion court violated well-established rules of contract interpretation. And one of these rules of construction is the maxim of a gestum generis, which provides that where, in a clause, general words follow specific words, the general words will be interpreted as modifying the specific words preceding them. We cite many Massachusetts cases applying this principle in our reply brief, as does the Academy of Trial Lawyers in its excellent amicus brief. We would respectfully submit that by ignoring this rule and the rule of construction, that terms in an insurance policy should not be read in isolation, but should be read in conjunction with the words around them. The motion court also did violence to the well-established rule of construction that contract terms, where ambiguous, will be interpreted against the insurer that drafted those terms and in favor of the policyholder. And for important reasons of public policy, this rule applies with particular force to policy exclusions, as here. I would welcome any questions from the court.
All right, Justice Link. Justice Link?
I had it on mute. I'm sorry. Now can you hear me?
Yes.
Okay.
Yes.
Okay, good. My first question is whether you could help us to sort of put this rule that you're asking for in context in terms of what other states have done with this and what the commentary by experts has said about whether the term physical abuse should be construed as you want it to be construed. And then the second question would be how you contrast physical abuse with mental abuse.
That's a good question, Your Honor. Starting with the first part of the question, really there's only a very small pocket of cases from Connecticut and Massachusetts, none, of course, from this court, that have dealt with the abuse and molestation exclusion by isolating the words physical abuse. If you look at the broad case law that we've cited in our brief, the cases are fairly uniform in finding the exclusion to be unambiguous in the context of cases involving sexual molestation or abuse of that nature. But in the cases, and we cite many of them, I should say at least half a dozen for various jurisdictions, that say once you separate physical abuse, you can't separate physical abuse, or if you attempt to, it renders the clause ambiguous, and then we thus are required to employ the general rules of construction that ambiguous terms should be construed against the insurer. And as to mental abuse, Your Honor, I think it would fall into the same category under the rule of construction as gestum generis, which means that it modifies the term in front of it. And I would suggest, Your Honor, that it's an interesting question, although not necessarily applicable to the set of facts we have before us, because I don't think there's any allegation that Mr. Krusell engaged in any form of mental abuse here.
No, I know that. I'm just saying, it seems to me, though, that we have to understand what the various words of the statute mean, don't you think?
I agree with you, Your Honor, as the insurance policy. And mental abuse, as to both mental and physical abuse, we speak in our brief as to what the general definitions of these terms are. And when you talk about mental abuse, many of the cases discuss it in the context of the numerous statutory definitions and definitions in dictionaries that talk about abuse as involving some form of control, whether it be by supervisors at a nursing home, whether it be by the people caring for children at a school or a daycare, but some form of control has been found to be necessary, or at least in the definitions that we cited in our briefs and that the amicus cited. There's some form of control. There's also in these definitions, both statutory and from the dictionaries, generally some form of intentionality. And the one definition of abuse that was seized on by the motion court here differs from that, and I would suggest it's very much in the minority of the definitions of abuse that you'll see in the statutory definitions and in the definitions from the dictionaries.
Thank you.
Justice Lilly.
Thank you, Chief. obviously, we want to get at whether the exclusion is ambiguous, since, as you said, if so, it's going to, in order to the detriment of the insurer. But as it relates to physical abuse, there's nothing in the language of the exclusion that suggests repetitive behavior, and the insurance company's position is sort of a straightforward argument, which is, how can a physical assault not constitute physical abuse? Could you answer that question as posed by the insured? Thank you.
Yes. Well, I would start by quibbling, I'm afraid, with the term physical assault. Although Mr. Krusell was charged with an assault, he ended up pleading to a misdemeanor, and we know that his recounting of the facts involved putting his hands up to push a phone away from his face to get the light out of his eyes, and he testified specifically that this was an instinctive action. And I would state that although he did plead to a misdemeanor, which has since been expunged, I would quibble with calling it a physical assault. But again, I would get back to the definitions of abuse, which all but one seem to require some form of intentionality that simply wasn't present here. And I understand that the insurance company's argument has some appeal in its simplicity in just saying abuse means physical maltreatment. But I would say that just saying abuse is physical maltreatment, any form of physical maltreatment, whether it's intentional or not, is just overbroad and was not what was intended when this provision was drafted to deal with concerns of sexual assault and corporal punishment. And that's indeed the title of the portion of the policy that has this exclusion.
So there's an issue raised by your answer, which is the implications of the disputed fact in this case. Is it your position that Judge Connors, in the summary judgment decision, really didn't take into account that there were disputed fact as it related to the incident?
Well, Your Honor, that is a difficult question, because the court did seem to suggest even crediting Mr. Krusell's testimony. So on its face, he does say that he's accepting Mr. Krusell's testimony. However, there's also some emphasis of what Mr. Hoffler reported to the Newport police, and in my view, it would be very difficult on Mr. Krusell's testimony to bring this within a definition of abuse, in that his testimony was quite clear that it was an instinctive reaction to push the phone out of his face. So while he does say that he's crediting Mr. Krusell's testimony, it appears to me in some ways that he is accepting another version of events.
Okay. Thank you very much. I'm all set.
Thank you.
Justice Buck.
Hi, good morning.
Good morning.
Just so I understand your position, would you say that the policy would it exclude an accidental? I'm just trying to figure out. I know that your client says it was an accident, and that the court below said it doesn't matter whether it was an accident. The question is whether there was an injury. Is that fair?
Yes. My reading was that the court found that it didn't matter whether it was intentional or not.
Right.
Whether it was an accident, because he was physically touched and hurt.
Right. Okay. All right. That's fine. I don't have any other questions. Thank you.
Thank you.
Justice Cipher.
Thank you. Good morning. I just have one or two questions, and what I'm curious about is what you think the defendant's definition of abuse would do to coverage for violence against women and children in the home.
Well, by saying that the definition of physical abuse is any physical maltreatment, it clearly would seem to extend to bar coverage for any resulting from any violence in the home. If it can bar coverage from an incidental contact that caused someone to lose their balance and fall on the ground, it certainly would apply to bar coverage for any intentional or any beatings or punching or anything of that nature.
And you say that's true of the defendant's definition?
Yes, I would think so. When you say defendant, you're talking.
I'm sorry. Mr. Krusell.
Oh well, Mr. Krusell is my client.
Oh, I'm sorry. I got your name mixed up.
I'm sorry, no problem. But my understanding about that, Your Honor, is that's not really particularly problematic because that type of offense has fallen under the intentional acts exclusion, which is also a standard exclusion in all of these policies. I do think that under the insurance end, my client would certainly acknowledge that domestic violence would fall under the type of physical abuse that was contemplated in the abuse and molestation exclusion.
All right. I'm content. Thank you.
Thank you.
So I have a series of questions. We have two different fact scenarios here, right? We have the fact scenario of the injured Mr. Hausler saying your client ran at him and pushed him off the ledge there. And then you have your version, which is he's showing him the picture of the fish, and he has an instinctive reaction, puts up his hand and knocks him over, right? Those are the two versions, right?
Your Honor, and I'm sorry, I'll let you finish your question.
Yeah, those are the two different fact scenarios, right?
Yes, although I might want to address that to some degree after I've heard your question.
But so I guess my first question is your version in the summary judgment record, meaning is it properly considered? Because we get it only in through the psychological evaluation, right? Your client never gives a deposition or anything else, right?
No, Your Honor.
Okay, sorry, I'm wrong in fact. Correct.
Well, he did sit for a deposition in the coverage action, of course, and that's what we've quoted in our brief. But you're right, early on, all that was conveyed when his criminal counsel did convey to the insurance company a kind of miniaturized version that's what happened. He pushed the thing out of his face. But they never really heard from my client until that psychological statement in terms of specific statements. No, that's correct.
Right. But I'm just trying to get a sense from in the summary when the judge was looking at the summary judgment record. Again, I always have to sort of remind myself about what's admissible and what's not, because obviously you don't need to testify. But do we have the proper evidence of your version of the events?
Absolutely, Your Honor. Because recall that this is not a fight over the duty to defend. The insurance company came forward and defended from the very outset. This is a coverage decision after that stage that involves
so it's
whether there's indemnification. So the depositions of all the parties are relevant. Mr. Krusell has given a detailed deposition, and I should mention also that Mr. Hausler gave a deposition that did not differ substantially from what my client said. He said that my client was only 1.5 to 2 feet from him when he showed him when he stuck the.
Okay, I'm comfortable with that part. My questions really are focused on the difference. I get your argument that this is ambiguous, and that may be a winner for you, but I'm also trying to understand the difference between intentional act, physical abuse, and what's covered. And I'm having trouble because we're going to have to give guidance in the end of what this provision means. So could you help me articulate what the difference between physical abuse and intentional acts is using the two different versions of the case? Meaning, for example, let's take the pushing. I take it if we accept Mr. Hausler's versions of the event, this is an intentional act, right?
Yes, and I don't think that. I think my client would admit that putting his hands up was intentional. It's not like some forces overtook his body. But under the very well developed body of case law involving the intentional act exclusion, it's not whether you intended the act, it's whether you intended the injury. The specific injury. And I think that case is very well settled. But I did want to, that law is again, I need help. To me, if we accept Mr. Hausler's version, this is clearly an intentional act, an intentional injury. If we accept your version, I take it it's neither. Well,
right?
Certainly, at best, it's a disputed issue of fact, and that's what we've asserted in terms of the court's error.
Okay, so what is the physical abuse? I understand you say it's ambiguous, but what is then the definition of physical abuse that helps us distinguish it from intentional acts?
Well, I think if you look at the case law, it appears that physical abuse, the discussion of the term physical abuse, again, tends to turn on whether there is some control by the abuser, whether there is some intent to harm. It's a difficult standard, but I think when you must just read it against the section it's in, which is one that deals with sexual molestation and corporal punishment. And
but that, again, it doesn't help me much. I understand the sexual molestation is, I think we have a clear understanding. It's meant for basically those church cases. That's where it was created, right?
Right.
But again, corporal punishment. So if a parent spanks his child and hurts the child, that's what we're talking about?
I think that's one of the areas, absolutely.
Okay, so then what, this physical abuse element, because we're not going to be able to just write an opinion that says this is ambiguous. We're going to, at our level, we got to give some definition to this. Does it require a pattern? Does it require a controlling relationship? What are the elements for us? Because that's what we're going to need to write.
Well, Your Honor, I think that in our brief and in the amicus brief, there are several proposed definitions that do suggest some element of control is necessary.
So there needs to be an imbalance of power? Is that what you're saying?
That's right. And if you do look at the cases that we cite, there are several that talk about that. There's one case that involves two nursing home residents where one of them attacked the other with a steel pipe, and that was found not to be excluded because there was not that level of control. So I do think there are some workable definitions in the amicus brief and in our brief that are not as all-encompassing as the one that's been asserted here by the insurance company and that was adopted by the motion judge.
Yeah, that's all I have, Chief.
Right. So we're 22 minutes, so I will be brief. Help me to understand, Mr. Trulin, the best that am I correct that the best that you could accomplish today is to have us reverse the allowance of summary judgment and essentially remand it for a trial for a determination by a preponderance as to whether or not the version of events of Mr. Hausler is true or the version of events of your client is true?
Well, Your Honor, that would be the relief that I'm requesting. I do think that there was a cross motion by my clients as to all of these things, which was denied. My understanding is that is not an appealable determination. I do think, depending on how you phrase this, it may make it so clear for the parties that a trial might not be necessary. But that is the relief that we've requested.
But so just to understand, again, I don't know how this case will play out, but let's assume that we accept your argument for the sake of this question. There still is going to be another argument that it was an intentional act meant to injure, correct?
Yes, there's an argument, but yes, there is an argument.
Okay,
it's actually a portion of what's been asserted by the on appeal and was asserted on summary judgment by the insurance company. I would note that we've cited at least 4 or 5 cases in our brief, which I'm happy to recite, that found under the intentional acts exclusion, even in cases where parties were convicted of assault and battery, that is not a sufficient finding to bring the contact with to bring the conduct into the category of conduct where intent can be inferred. So in many of those cases, the insurance company had moved for summary judgment on intentional acts due to the fact that someone was convicted of an assault and battery, and the court still found that the intentional act exclusion would not bar coverage.
Okay, but am I correct? Put aside the criminal conviction, put aside the misdemeanor conviction, which I guess now, according to you, has been expunged. There is a dispute of fact as to whether or not your client, with an intent to injure, engaged in an intentional act of assault against Mr. Hausler, correct? That would have to be resolved at trial, even if you were to prevail here, correct?
I suppose that's correct, Your Honor. I do think, in rereading all the depositions in preparation for today, I realized that although Mr. Hausler's criminal complaint differed sharply from what my client testified, when Mr. Hausler was actually deposed a couple of years later, his deposition testimony was remarkably similar to my client's in terms of the actual events of them being only 2 feet apart and my client pushing him after he stuck the phone in his face. So, but it is an issue, Your Honor.
Okay. I have no further questions. Any questions from the other justices? And hearing none, Mr. Trulin, thank you, and we'll turn.
Actually, I'm Mr. Beal, just to be clear. I'm sorry.
You're Mr. Beal. You're right. You're at the bottom of my list, and so I apologize for that. So,
no problem.
Mr. Trulin, now we've been calling you Mr. Trulin for a while, so now, in fact, we'll hear from Mr. Trulin.
Good morning, Mr. Chief Justice and Associate Justices. May it please the Court. My name is Kevin Truland, and I represent Dorchester Mutual Insurance Company. I would respectfully submit that this exclusion is clear and unambiguous. The exclusion, essentially breaks down 4 different categories of conduct. 2 categories of conduct precede the term physical abuse, where it says sexual molestation and corporal punishment. There's been an argument raised by the defendants that this is something that's geared only to sexual molestation, and I would submit that based upon the wording of the exclusion, where you've got the words or phrase corporal punishment juxtaposed between sexual molestation and physical abuse, we're looking at four separate categories of conduct. And I would submit that no reasonable insured would interpret this exclusion to refer solely to sexual molestation. The courts have indicated that the exclusion eliminates an entire category of injury, one of them being physical abuse, which the Minnick Court has defined as physical maltreatment. I believe that the Minnick Court was well reasoned. The term is the case cites to the Webster dictionary definition of physical abuse as physical harmful treatment, and the Black Law Dictionary definition of physical or mental maltreatment. The court rejected the claimant's argument or plaintiff's argument in that case, and I think correct that physical abuse amounts to non-accidental physical injury. I also take issue. There's been a contention here that Mr. Krusell acted instinctively or accidentally. I completely disagree with that characterization of Mr. Krusell's deposition testimony. He's admitted during his deposition that he placed both his left hand and his right hand on Mr. Hopler's right arm and pushed him. He admits to pushing him, and this was not an accidental conduct. And I think counsel for the Krusells just stated that he in fact pushed Mr. Hopler. The uncontested testimony, Mr. Krusell ran from the scene after he committed the act. The uncontested testimony from both Mr. Krusell and from an eyewitness, Bradford White, that was with him, was that the force of the push caused Mr. Hopler to leave the ground and land on a parked car after being pushed from the sidewalk. So this is not an accidental act on the part of Mr. Krusell, and in fact, he's admitted that he pushed Mr. Hopler. So we get down to a question of I don't think that there's any question that he pushed Mr. Hopler and that this was not an accidental injury. Getting to the question of intent, the Minnick Court and other courts, including the VC Court, which is a federal district court case that I've cited in the opinion, they've held that the exclusion does not refer to intent, and there's another separate exclusion that deals with the issue of intent, the intentional conduct exclusion, which is exclusion number 1, and that already covers intentional conduct. So that reading intentional conduct into this exclusion would render it redundant, because if intentional conduct was required, there's already a policy exclusion that applies. Getting to the question,
I'm afraid you're at 4.5 minutes. So
I'm sorry.
You and invite questions from Justice Lang.
All right. Can you hear me?
Yes, I can.
Okay, I'm not on mute, right? I'm not muted. You can hear me. Good. Thank you. Anyway, I was going to ask you pretty much the same question I asked the other side, which is about the way other states have handled the exclusionary language of physical abuse, the meaning of physical abuse, and the extent to which there is a distinction in the cases that the counsel, your brother, was suggesting between cases which involve physical abuse in the context of sexual abuse and those which do not. Is there such a distinction in the cases?
Well, I cited a number of cases that have dealt with the physical abuse exclusion on page 36 of the memorandum. There are a number of cases that have been cited by the Krusells, which deal with different policy language, where it's an abuse and molestation exclusion, and I would submit that those cases are inapposite. But
because the language as a whole is different, is that what you're saying? The language of the policy is different, you're saying, in those cases?
Yes, there are many cases that are cited by the Krusells where the policy language itself is different. Just with respect to one case that's been mentioned, the Riley versus Maison Orleans, where first of all that was an exclusion that said injury sustained by any person arising out of sexual and/or physical abuse. But the court had no. That's the case where the court talked about being in a position of control, and there's no citation to any support for that ruling in that case. And I would respectfully submit that the well-reasoned cases, the VC case and the Minnick case, talk about the term physical maltreatment. There's another case that I've cited, a Superior Court case from Massachusetts, on page 38 of the memorandum, where essentially the Superior Court adopted the reasoning of the District Court of Connecticut, Federal District Court of Connecticut, in the VC case, and where the court also held that the language referred to physical maltreatment. And there's a quote in that where it states that an improper use or maltreatment of another is abuse. Stated in another way, conduct constitutes abuse if it deviates from proper use, and abuse of another person is therefore maltreatment that deviates from a baseline societal understanding of what is appropriate conduct. And that's essentially what's been adopted, the reasoning that's been adopted by the Minnick case as well. That's a Massachusetts unpublished appeals court decision.
Yeah, we haven't got any published opinions, in other words.
Well, there are some published opinions
by appellate courts.
There's a Merrimack Mutual Fire Insurance Company versus Ramsey on page 36 of the memorandum. That's 117 Connecticut Act. That was a stabbing case where court said that the physical abuse exclusion unambiguously barred coverage for stabbing by a mentally ill person. So that's another case where the court found that intentional conduct is not required with respect to the physical abuse exclusion. The Superior Court case, the Shearer case, also involved a mentally ill person. It was an unfortunate set of facts where her husband strangled his wife and had some mental issues, and the court found that the physical abuse exclusion barred coverage, and essentially relying on the holding in the VC case, the Federal District Court case.
Okay, thank you.
Thank you. Mr.
Mr. Trulin, I want to ask you about the reservation of rights letter in issues of waiver and estoppel. It took a number of years of litigation, at least according to the insured, before the issue of physical abuse came out. And obviously, the insured's counsel put a lot of emphasis on what he viewed the law to be as it relates to intentional conduct. Why isn't the insurance company stopped here, and why wasn't there a waiver as it relates to physical abuse?
Well, beginning with the question of waiver, Your Honor, the Merrimack Mutual Insurance Company case, Merrimack Mutual Insurance Company versus Nonaka, 414 Mass 187. That case holds that the four corners of what a policy covers cannot be waived. So an insurer can waive policy conditions, but what a policy covers under the four corners of the insurance contract cannot be waived. With respect to the issue of estoppel, essentially what we have here is number one, the carrier defended from day one under a reservation of rights, relying upon the intentional conduct exclusion, and the evidence that was in the possession of the carrier indicated that the insured had been charged with a felony, and that the and that the intentional conduct exclusion applied. We had answers to interrogatories that were served in the underlying case where Mr. Hoffler indicated that he was physically attacked. We have police reports in the possession of the carrier very early on in November of 2014 giving Mr. Hoffler's version and Mr. White's version of these events and indicating that intentional conduct applied. The representation, estoppel requires detrimental reliance, but reasonable reliance on the part of the insured. Essentially, our position here is that the Krusell, the insureds, are completely ignoring the evidence, substantial evidence in this case, that we had an exclusion based upon intentional conduct, where the facts indicate, I would submit the facts indicate that harm was substantially certain to occur, and we in part move for summary judgment on the issue that the intentional conduct exclusion would apply. But in any event,
let me ask. I'm sorry to interrupt you. What was the timing of the son's, the insured's son's deposition relative to the summary judgment motion?
The insured's son's deposition, I have that written down.
But the most important point is whether or not there's disputed facts on intent at the time of the summary judgment motion is really my point.
The Krusell deposition was October 5th of 2017. But with respect to that last question, Your Honor, as I indicated earlier, I'm looking at the deposition transcript at page, Appendix 3, page 171. That's where Mr. Krusell admitted that he placed his both hands, his right arm and his left arm, on Mr. Hoffler's right arm. So he's got Mr. Krusell's two hands on Mr. Hoffler's right arm, and he admits that he pushed him. And so essentially, he's admitted to intentional conduct that we submit amounts to.
But that's not enough. That's not enough. Assuming in the light most favorable to your client, that's the case. That's the intentional act. That's not the consequences. And Judge Connor's decision is after that point in time. So I understand from your perspective this easily falls within, from your facts, easily falls within the intentional act exclusion. The question is whether or not there's a disputed fact relative to that.
Well, the question, there's two issues, Your Honor. One, whether we're looking at the physical abuse exclusion, because under the physical abuse exclusion, we're taking a position there that intent is not required at all.
Yeah, I appreciate that.
But what it is the act. So and the other side of that is that on the intentional conduct exclusion, you would have to show some intent to cause some injury. But we submit that on these undisputed facts where Mr. Hoffler was pushed hard enough to have his feet leave the ground, that it was substantially certain that he was going to be injured and sustain at least some bodily injury. And getting back to the issue of estoppel, it's our question there that any reliance was not reasonable. It was first of all reliance on representations of counsel as to whether the intentional conduct exclusion, whether the carrier had a colorable argument for the intentional conduct exclusion. So it was not a representation by the carrier there. It was a representation by counsel that I would submit was ignored the evidence on the intentional conduct exclusion where from Mr. White and from Mr. Hoffler.
Thank you. That's all I have, Chief.
Justice Budd.
I don't have any questions.
Justice Seifer.
Yes, thank you. Do you agree, counsel, that you don't have to state a reason for when you reserve your rights?
Well, yes, I do not see that we have to, that there's any Massachusetts law that states that a specific exclusion exclusion needs to be raised in a reservation of rights letter. The Minnick case dealt with that issue. That the abuse exclusion was not raised until until the time of summary judgment and in the pretrial memorandum in that case. And the Minnick court held that there was no waiver in that case.
Okay, but can you explain the rationale for that rule? Like, what is the reason that you do not have to state why you're reserving your right? What harm would it produce to you if you did have to?
What the case law in Massachusetts essentially says that when the insurer exercises dominion and control over a case, and a long period of time goes by where the insured may rely to the insured's detriment on the conduct of an insurer and not raising any issue of coverage, and the insured's position in the litigation may be compromised in some way, such as the Safety versus Day case is a case where the carrier didn't raise a regular use exclusion until very late in the case and had never reserved its rights here and had exercised dominion over the case and actually had in some way mishandled the defense through defense counsel. But so in this case, we never exercised dominion over the case, and the insured was on notice from the beginning that the insured could take action to protect himself by insisting, which the insured did in this case, insisting that the insured control the defense. So very early on in this case, from day one, the insured was on notice that there was a coverage issue here, and it was the intentional act exclusion that was raised, but the insured was put on notice so that the insured was able to protect himself from the defense aspect of the case and retain his own counsel to provide the defense.
So the harm to the insurance company is what?
Well, I think the harm to the insurance company is that there is no bright line rule about raising every single line of defense, and also I think it's a question of balancing between the insurance company and the equities with respect to the insured. All of the case law that I've seen in Massachusetts state that the insured issues a reservation of rights letter, it protects itself from questions of estoppel, and then under the no-knock case, the insured cannot waive the four corners of what insurance policy covers.
Okay, thank you.
Justice Caffrey.
I'm good.
I have the same question I asked your brother, which I'm having trouble distinguishing what this exception is now. If we have two kids, say you're a homeowner, you have two children fighting in the back, two 12-year-olds, and they're hitting each other. They're roughhousing. Are they covered by this or not?
Well, I think that's a good question. The way that I look at this exclusionary language is that it's talking about a type of conduct, and it's maltreatment. Roughhousing may have some different context there, where, for example, I don't think the exclusion covers negligent conduct. So if someone were to drop, I think there's a cited case that I read where someone had been charged with murder, but of an infant. But at one point in the day, there was some evidence that same person had dropped the infant, negligently dropped the infant when she was carrying it. And the court, I just have trouble.
Your definition seems so broad, and you seem to read out the word abuse. Abuse has, a lot of freight, right, in our world. It's not just physical, maltreatment or mistreatment, it has a sort of a stronger connotation, doesn't it? Involving control and systematic, or at least a pattern of behavior.
Well, I would respectfully disagree with that, Your Honor. The cases talk about the contract language and the definition of occurrence in this case. When repetitive conduct is required, the policies expressly so state. So the definition of occurrence in the policy refers to repetitive conduct. And another thing that cases are saying is that it doesn't make any sense to say that the first act of abuse, for example, in the Shearer case, the act of strangulation, was just one event. It doesn't make any sense to say that that first event does not amount to abuse, and that you would need multiple instances of abuse in order for
any type of physical behavior that's not sort of accepted physical touching is covered here. So why would we need why do we need the sexual molestation point? Shouldn't that be covered by your definition of physical maltreatment?
Well,
isn't everything else repetitive?
I could respond to that. And one thing I can think of there would be you may have, for example, in the case of an underage individual, someone who is too young to consent but actually does consent to molestation, and there may be an issue or an opening for someone to argue, well, that wasn't abuse because the person the victim didn't consider it to be abusive conduct. So you've got something that does amount to sexual molestation if it's an underage child. So I think with respect to sexual molestation, that the exclusion is specific in order to avoid that kind of an argument to say that the exclusion is ambiguous with respect to molestation when it requires physical abuse, because there may be an issue there.
I'm all set. Thank you.
Mr. Chief Justice Gantz, do you know when this provision became a part of insurance policies in Massachusetts?
This is a 2010 policy, and it's been there since at least 2010 to 2010 edition.
Okay. I want to turn you to the Fells Acre insurance case. You're familiar with that? Although I don't think it was cited by the parties.
Yes, I think we did cite the Fells Acre case.
So in that particular case, Justice Abrams, on behalf of this court, I think it was 1991, says we join the great majority of courts which says that sexual molestation involves an intent to injure. So
yes. With
regard to Mr. Amaral, he's not going to be covered because he was found guilty of sexual molestation, and therefore they're not going to be within the scope of it. But the Fells Acre Daycare Center, it said, there was no vicarious liability, and I think as to that, it denied summary judgment because, after all, they were not vicariously liable for it. And I guess then the question was whether there was negligent supervision. So would this provision essentially have changed the law and said that if somebody sues Fells Acre, they're not going to receive coverage because it involved sexual molestation or physical abuse?
I would agree with that. I would say yes, because this exclusion, when you read the exclusion, unlike the intentional conduct exclusion, this refers to a type of conduct, and it is not specific to any. It's not insured specific. So, for example, the Bagley case was a criminal acts exclusion case, and while I'm referring to that case, I would also mention that the courts in Massachusetts have upheld the assault and battery exclusion in Fuller versus Financial First Financial Insurance Company, 448 Mass 1. But the Bagley case was a criminal act exclusion case involving a motel where the perpetrator of a crime, a rape at the motel, was a patron of the motel. And the court said that exclusion applied across the board and did exclude the claim against the motel, and so that the claim of rape was not act specific. It applied across the board. And the way I read this exclusion, I would agree that yes, that it would apply across the board, and we're looking at the type of conduct, not who committed the act.
So why should we not interpret it in view of its apparent purpose, which is to protect insurers from having to pay out claims on behalf of churches and schools and gymnastic academies, which are being sued because of sexual molestation or corporal punishment or physical or mental abuse? Why should we interpret it essentially to be expanding the scope of the intentional battery exclusion to say you don't need injury, you don't need intent to injure, you just need an intent to abuse?
Yes, well, there's a couple of questions there, but I think number one, that an interpretation that limits this to sexual molestation, I think
I'm not suggesting that. I'm not. That's not my question. My question is, certainly corporal punishment can occur in the context of a school or church school. Why should we not interpret it to be in the context of protect insurers against liabilities from schools, gymnastic academies, churches, doctors' offices where there may be, as opposed to essentially as opposed to a provision which for all practical purposes you define it, would essentially be amending the intentional act exclusion to say you don't need to intend to injure, you simply need to intend to abuse.
Well, I would answer that saying that there's nothing in the exclusionary language that limits it to schools or doctor's offices. It's talking about type of conduct that corporal punishment could occur in the home, it could occur in the school, it could occur basically anywhere, and there's nothing in the language of the exclusion that limits the exclusion. I point again to the court's decision in Bagley where there was an illegal act exclusion that applied across the board to illegal acts. And the court in that case held that exclusion was very broad, but it was not illusory because it covers a number of things, just limited that particular type of conduct excluded, and it was the court enforced the clear and unambiguous language of the policy. So I would submit that there's nothing in this exclusion that would limit it in the way that you've suggested. And the courts have not had either. The courts, the cases I cited in the memorandum that this exclusion have that it does not require intent, and that it applies to these different scenarios. The VC case was a husband who threw a carrot at his wife. I've mentioned the stabbing case. I've mentioned the strangulation case. But the courts have not limited it. And the question of intent, the courts have looked at the issue of the intentional conduct exclusion and compared this exclusion to the intentional conduct exclusion and said, that would be redundant to require intent. This exclusion, that's already present in the intentional conduct exclusion. So I think the fact that the intentional conduct exclusion is present in the policy is a reason for the court to hold that intent is not required on this exclusion.
So why should we not, this will be my last question, why should we not interpret this in terms of its clarity? If it's not clear, you lose on this issue. That we will interpret it in terms of its clarity only to apply to sexual molestation, corporal punishment, and physical or mental abuse in the context of a relationship. There's an imbalance of power or some degree of control. That is, a teacher-student, a doctor-patient, a church official with a penitent.
Well, again, Your Honor, I don't believe that there's anything in the policy language that puts any type of limitation like on the policy language. I referred to the Riley versus Maison Orleans case. It's a Louisiana case at 829 South 479 that referred to this issue of abuse being someone in control. When I read that, there was absolutely no support in the courts of the opinion for interpreting the word abuse to require control. So that's something that's argued by the claimants, but I don't think that this policy language justifies an interpretation that requires it limited to a person of dominance or control. I think the well-reasoned cases is the Minnick case and the VC case and the other interpreting this precise policy language that have held that it refers, that it's a broader that applies broadly.
Okay, I have no further questions. Are there any questions?
Yes, I have one. This is Judge Lank. I forgot to ask you about the question I asked your brother, which has to do with mental abuse, and if there are cases construing that. Because I'm having trouble, particularly following Chief Justice Gance's line of inquiry. I'm having trouble understanding what mental abuse would mean in this context.
I thought about that, and mental abuse. Number one, there's a bodily injury requirement in the policy where mental abuse in and of itself would not amount to a bodily injury. So there may be a reason for a finding of no coverage simply for a claim of mental abuse.
I'm sorry, I didn't understand what you just said. It means that it would not be excluded, or would be excluded, or what?
The policy covers bodily injury. So there's a case, Metropolitan versus it's a Metropolitan case. I don't think it's cited in the memorandum, but the court held it's an SJC case where the court held that for example, in a negligent infliction of emotional distress case, it's Metropolitan versus O'Neill is the case. But the evidentiary requirement in an emotional distress case of bodily injury or some evidence of bodily harm as a result of mental injury, that amounts to bodily injury for purposes of insurance. So what I'm saying is that mental abuse alone may not amount to a bodily injury, but I would submit that mental injury or mental abuse could be present in the context of physical abuse. So you may have both physical abuse and mental abuse in the same case, which I could see an argument being raised by counsel that if mental abuse wasn't mentioned in this exclusion, that there would be no coverage for physical abuse, but that the mental abuse part of it would be covered. So I think to the extent that mental abuse and physical abuse are both present, you may have a situation where it amounts to bodily injury. And I think similar to what I was saying earlier about a young person being molested, that you want to cover different situations to rule out an argument that mental abuse is covered when so in order to prevent that argument, the mental abuse is referred to so that it's expressly mentioned and covered by the exclusion.
All right. Any further questions?
I have one follow-up from Justice Lank's question. This is Justice Pfeiffer, and that is, you say mental abuse is excluded, but bodily injury you'd have to have physical abuse for bodily injury. But research is showing more and more that mental abuse can have long-term chronic bodily effects. Would that not end up being covered if there was some bodily injury as a result of mental abuse?
Well, what I was saying earlier, the Metropolitan versus it's McNeil. I'm sorry, I think I said O'Neill, but the Metropolitan case. It was Judge Stossman wrote the opinion, and that case held that the physical injury requirement or the evidence of some physical manifestations in a mental distress claim, that's the court principle that is necessary in order to sustain a tort claim for a negligent infliction of emotional distress. That does not amount to bodily injury for purposes of insurance coverage. So if you have mental injury, as the state of the law in Massachusetts right now, mental injury that results in physical manifestations is not covered. Purely mental injury with physical manifestation is not covered, and there are other cases on that also.
Okay, thank you. I'm fine. Thank you.
Okay, thank you, Mr. Trulin. Mr. Beal, our apologies for confusing who you were. We know who your clients are, so we're not going to confuse them. And this will close the oral argument. So I will then commence on a separate line the ensemble among the justices. Thank you all.
Thank you, Your Honor.